Hello, everyone. For folks joining, we'll get started in about 1 minute. Thank you. Right. Hello, everyone, and welcome to the Environmental Law Institute's event, Community Lawyering for Environmental Justice Part 7, Connecting Communities with Federal Funding. My name is Madison Calhoun, and I'm the Senior Manager of Educational Programs here at the Environmental Law Institute. I want to thank all of you for joining us this afternoon, as well as give a massive thank you to our wonderful speakers who have been preparing a fantastic program for you all. Today's event is the 7th part of our Community Lawyering for Environmental Justice series, designed for attorneys to receive continuing legal education credit through practical education about the practice of law in relation to environmental justice. We've created a worksheet to go along with this event, so please be sure to download the written materials from the event webpage. We will post a link in the chat to that as well. I want to take a minute or so to go over the continuing legal education component of this program. So ELI is an accredited CLE provider in Vermont and Pennsylvania, so the program is automatically approved for 1.5 hours of standard CLE credit in those states. Additionally, ELI has applied for approval of 1.5 hours of standard CLE credit in California for this event. Please check your state's CLE guidelines to see if your state offers reciprocity with the states in which we are pre-approved. If you're seeking CLE in a state in which we did not apply for accreditation and also which does not offer reciprocity with Vermont or Pennsylvania, you'll need to apply for CLE credit individually with your state. Within approximately 1 week of this program, we will email out certificates of attendance to anyone who requests one and fulfills the requirements. Certificates of attendance are used to verify attendance for CLE purposes, and in many cases, attorneys can use these to apply for individual CLE credit with their states. To receive a certificate of attendance, you must be online throughout the entire program. We will be verifying this with our software's attendance report. You must also fill out the certificate of attendance request form after the webinar. This was already sent out to you from our ELI team via email, but we'll also post the link in the chat. And you'll also need to submit the correct code in the certificate of attendance request form to verify attentiveness. So we will read out the code out loud and post it in the chat at some point during today's program. Should you have any questions related to CLE, please contact us at cle@eli.org. Today's program will be recorded and posted publicly to ELI's website and YouTube page. Additionally, we will be taking audience questions at the end of the program, so please feel free to put any questions you have in Zoom's Q&A box as you think of them. While the chat will be open for you to post your observations, please do put any questions that you wish our speakers to address in the Q&A box rather than the chat. And with that, my housekeeping remarks are finished, so I will now go ahead and turn things over to our wonderful moderator, Zoe Vogel. Zoe is currently a public interest legal fellow here at the Environmental Law Institute and previously served as a law clerk at ELI during the summer of 2022. Zoe received her JD with honors from Tulane University Law School, where she served as the editor-in-chief for the Tulane Environmental Law Journal, a student attorney with the Tulane Environmental Law Clinic, and an intersectionality chair for the Environment and Energy Law Society. Zoe, I will hand things over to you. Thank you so much to all of you for being here today.
Thank you so much, Madison. We have a great education team that works very hard behind the background, so we are so happy to have them. As Madison mentioned, my name is Zoe, and I am currently a law fellow at the Environmental Law Institute, and I'm so pleased to be moderating this really excellent panel today. We have a great lineup of panelists, and I'm really excited for them to have this opportunity to share all of their knowledge with you all. As far as the presentation flow for today, we're going to start with introductions from each of our panelists individually, so that they can give us a little insight into their work and their organizations in this space. And then we will move into discussion topics. As Madison mentioned, if you have any questions throughout the webinar, please go ahead and drop those in the Q&A box at the bottom of your toolbar. Madison and I will be monitoring that throughout the program. And there's no need for you to wait. If you have a question, feel free to stick it right in. So with that, we will go ahead and meet our panelists. First, we have Rob Brenner. From 1988 until his retirement in 2011, Rob was the director of the Air Policy Office at EPA, where he played a key role in the development, passage, and implementation of the 1990 Clean Air Act amendments. He was also very active in developing voluntary partnerships with local organizations to help them reduce pollution in their neighborhood. Both President George H.W. Bush in 1993 and President Clinton in 1998 conferred on Rob the rank of Meritorious Senior Executive, and in 2003 he received the Distinguished Executive Award for Sustained Extraordinary Accomplishment from President George W. Bush. More recently, Rob completed a senior fellowship at the Nicholas Institute for Environmental Policy Solutions at Duke University and has served on the boards of the Center for Clean Air Policy, CMC Energy Services, and Princeton University Scholars for the Nation's Service Initiative. And with that, I will turn it over to Rob.
Thanks, Zoe. And thanks to the Environmental Law Institute for setting up this webinar and for inviting EPN to participate. The Environmental Protection Network was launched in 2017 by former EPA career staff and political appointees who offered their time and expertise to continue helping to protect human health and the environment. We now have over 600 EPA alumni volunteers. Our priority project is a pro bono technical assistance program. We help disadvantaged communities, NGOs working with those communities, and under-resourced state and local agencies. Types of support include navigating and understanding government programs, data and processes, gaining access to partners, allies and decision makers, and applying for funding. We have 10 community outreach associates, one for each federal region, along with our EPA alumni or volunteers across the country, working on community-identified issues. During the last couple of years, our volunteers have provided pro bono assistance in response to almost 450 technical requests. So that brings me to today's discussion. The American Recovery Plan, the Inflation Reduction Act, and the bipartisan infrastructure legislation not only provide industries with subsidies to transition to clean energy, but it also includes an unprecedented amount of economic support for states and communities to address long-term pollution while transitioning to green energy and clean economic development. And the Biden administration put in place the Justice 40 initiative to ensure that a substantial portion of those state and local resources will assist overburdened communities that need it most. So Justice 40 is set up in a way that we at EPA agree is at EPN, old habits die hard, but at EPN, agree is essential. Where possible, communities should be given the opportunity to set their environmental priorities. We can help them learn about options, but they make the choices, and then we help them obtain the resources. So one of the lessons my EPN colleagues learned during our federal service is that, and too often we learned it the hard way, is that when a policy window like this opens, it's important to move quickly, because unless you can point to results, support can rapidly wane. So of course, the first step in moving quickly is setting up the programs and grant mechanisms to distribute the funds, which the White House and the agencies are working days. And when I talk to my friends who are still there, many long nights to accomplish as soon as possible. But an equally daunting part of the challenge is how to build community awareness of these resources, enable them to engage in the application process, and effectively deploy those resources. EPA and DOE are putting in place a mechanism that can provide communities with information and assistance regarding those programs. They're establishing TICTACs, Thriving Community Technical Assistance Centers. 16 have already been selected, with a couple more in process. We are partners in many of them. Some are statewide, others are multi-state, and some are tribal. However, the TICTACs face an array of logistical challenges in getting their organizations up and running. And they are mostly combinations of academic institutions and NGOs. And figuring out how best to set those up is going to take some time. In the interim, it's important that the law firms, universities, and NGOs on this webinar continue to develop assistance tools and strategies and disseminate them as broadly as possible. So ideally, the TICTACs will be able to take over a portion of those functions in the future. But for our part at EPN, even though it's still early in the federal funding process, we have already helped under-resourced organizations access over $3 million in federal funds. We've also assisted over 100 entities apply for or get ready to apply for millions of dollars that have yet to be awarded. As proud as we are of those successes, we know it's small compared to the thousands of communities that desire and deserve the benefits of green energy and clean development. So we've prepared, and we will continue to develop, tools to assist communities. We created step-by-step application guides for 7 of the dozens of federal funding opportunities. These guides included a checklist with a suggested timeline for each step, a project narrative template, along with a sample narrative, and links to additional resources. All are available on our website, which is environmentalprotectionnetwork.org. And for assistance in using those tools, if you need help, you can contact us at info@environmentalprotectionnetwork.org. So currently, we're building 2 more guides for the Climate Pollution Reduction Implementation Grant, one for tribes and one for the general application. And we'll also develop a guide for the change grant opportunity that Alex and her colleagues are preparing to issue in the near future. So I hope and I expect that today's discussion will lead to opportunities for us at EPN to collaborate with other organizations and to share best practices related to what are most likely a once-in-a-career set of opportunities. Thanks.
Thank you so much, Rob. Up next, we have Alexandra Gallo. Alexandra is Special Advisor to the US EPA Office of Environmental Rights, where she advances environmental and climate justice initiatives through development of justice community grants. This program provides through that will invest $2 billion in grant assistance in disadvantaged communities. She requires developing innovative models for community transformation, including the Emergency Management Agency, California Strategic Council. Prior to these roles, she worked with California State staff on environmental quality, housing, and inequality issues. Alex is a first-generation college graduate with bachelor's degrees from California State University, Fresno, and grew up in California's Central Coast.
Great, thank you, Zoe. Thanks, everyone. Really appreciate the opportunity to speak to you all today, especially with all of the exciting opportunities around environmental justice. And I'm really excited to share this platform with folks of such amazing backgrounds, and really appreciative of Rob especially and EPN's work to get the word out about all of these funding opportunities. Just give a little bit of background about myself so we can jump on to the others. I know there were some audio issues, so I'll just summarize very quickly. As you probably caught at the tail end, from California, born and raised, grew up in the Central Coast, went to school in the Central Valley of California. Both areas, deep pockets of overburdened areas as it relates to socioeconomic challenges, pollution, other environmental challenges. And so through my kind of background, I was really interested first in law, actually, and I should preface this for everyone that I am not a lawyer. I work with lawyers a lot, and I feel I'm very skilled at arguing with them, at least I've been told, and also collaborating to find meaningful solutions. But I primarily work in the policy space and really see funding opportunities, investments like those provided through the Inflation Reduction Act, IRA, to really, I really see those as vehicles for change through policy. And through that, I started out initially with the state of California, really working on a very innovative, which has since become our landmark environmental justice program for the state, looking at how we can invest anywhere between $20 to $60 million at the neighborhood level to the most overburdened, marginalized communities within the state. I've learned a lot of lessons through that, especially around technical assistance and the type of work it takes to help communities prepare for investments that are really once in a lifetime. And the ones we have today are truly unprecedented. So I got to work directly with local leaders in various communities throughout California, as well as jurisdictions. And at the state level, really saw ourselves as the intermediate to help bridge that gap that often exists between local governments and communities who have a lot of mistrust due to governmental decision making, and how can we develop our programs in a way that meets the goals of communities and pushes government, particularly local government, to do a better job in working with community. This background has kind of shifted when I went on a detail to FEMA headquarters, particularly to help them develop a broader model for equitable resilience and providing technical assistance. So really setting up guidance materials and systems that folks at the federal level can learn and provide to different regions to be able to provide the assistance needed to communities. So with that, I've really found myself in positions where we're trying things for the first time, really trying to take innovative approaches, and I'm really passionate about process. So in my role today, I work at US EPA, Office of Environmental Justice and External Civil Rights. And as special advisor, I'm leading the development of the Community Change Grants, which is our $2 billion funding opportunity, which will be available notably to community-based organizations, and those in partnership of CBOs with local governments, academic institutions, or tribal governments. But for me, I really see my role as developing this program to work for communities, not EPA, but for communities, and defend this program and all of its principles. I'm also very passionate about process, so have worked through engaging with our environmental justice advisory groups and stakeholders that we have, and really trying to set up a program that can meet diverse community needs across the country and enabling them to take a very holistic approach to tackling the very complex challenges that exist on the ground. So I'll stop there. I know we have a lot more to cover, but yeah, thank you for having me.
Thank you, Alex. Can I get a thumbs up or thumbs down from the speakers if you can hear me? Okay, Wonderful. So next up, we have Jesse George. Jesse is a citizen of Cherokee Nation and a lifelong resident of South Louisiana, having been raised in Lake Charles, a major fossil fuel and petrochemical corridor. Witnessing the degradation and destruction that these industries have wrought on the health of fence-line communities and the natural landscape has instilled in him a lifelong passion for environmental justice. After receiving his BA in philosophy with a minor in religious studies in 2005 from Louisiana State University, he attended Tulane Law School with a certificate in environmental law. Much of his early career was spent at the Pro Bono Project, where he handled oil spill claims for indigent clients, and he is now the New Orleans Policy Director at the Alliance for Affordable Energy, which advocates for equitable, affordable, and environmentally responsible energy systems.
Thank you for that introduction, Zoe. CO, hello, everyone. I'm Jesse George. As you just heard, I'm New Orleans Policy Director with the Alliance for Affordable Energy. The Alliance has been around since 1985 in Louisiana, advocating for utility ratepayers in the state. We are the only consumer advocate for utility ratepayers in the state of Louisiana. Most states have a publicly funded office that fulfills this role. Louisiana does not. So we have done that job since 1985, both at the Louisiana Public Service Commission level and here locally in New Orleans. We're in the somewhat unique position. There's only 2 municipalities in the country that have regulatory authority over an investor-owned utility. One is the Council of Washington, D.C., the other is the Council of New Orleans. Under our home rule charter, our New Orleans City Council has regulatory authority over all utilities operating within Orleans Parish. As New Orleans Policy Director, I engage primarily with the City Council as regulator of Entergy New Orleans, which provides our electric and gas service here in New Orleans. The Alliance was actually founded here in New Orleans in 1985 in opposition to the construction of a nuclear power plant called Grand Gulf, which is in Port Gibson, Mississippi, which has actually been in the news recently because it's been the subject of litigation at the Federal Energy Regulatory Commission. And the FERC actually just recently ordered the company Systems Energy Resources Incorporated, which operates that plant, to refund customers $550 million due to Entergy's mismanagement of that plant. So the issue that was the founding issue for our organization is still with us today, something that we're still contending with. And so we see ourselves very much as not only a consumer advocate, but also as an environmental advocate. We see those 2 things as going hand in hand. We are very heavily focused on renewables and energy efficiency and creating resilience here in the city of New Orleans. You know, we've been at the forefront of the climate crisis in terms of the United States for a long time now. I was here during Hurricane Katrina, and it really hasn't let up since then. Really, after Hurricane Ida a couple of years ago in 2021, our city council started looking very intensively at hardening our grid and creating true resilience here in New Orleans for ratepayers and residents. So that's been the big focus of our efforts the last couple of years. So I'll leave it there for now. Thank you.
Thank you, Jesse. I think we have a couple of chats of other people who are also located in the South. So very happy to have it represented here on this panel. Last but certainly not least, Hannah Pearls. Hannah is a senior staff attorney with the Harvard Environmental and Energy Law Program, where she supervises research addressing federal agencies' authority to integrate equity considerations into disaster preparedness, relief, and recovery programs, as well as federal environmental justice initiatives. Hannah applies a human rights-based lens to her work, grounded in her pre-law school experience working with Cristasol, a human rights organization based in the Northern Triangle of Central America, providing legal and humanitarian assistance to families internally displaced by violence. Hannah received her JD from Harvard Law School and her BA with honors in environmental science and sustainable development from Columbia University. She serves on the Environmental Justice Legal Advisory Board for Alternatives for Community and Environment, and as the Law and Policy Co-Chair for the Climigration Network. Go ahead, Hannah.
Thanks. I will try and keep this extremely short because I'm anxious to get to the actual discussion. So I'm Hannah. Really great to meet everyone. It's been really to be part of this conversation. Thank you everyone for attending as a participant. Very briefly, just to explain what is EELP and what do we do on EJ and what don't we do on EJ, which I think is just as important. EELP is a legal research and policy function inside Harvard Law School. So we work directly with Harvard Law School students as research assistants to do a range of work. I lead our environmental justice and equity portfolio, which, as you mentioned in my bio, includes a pretty robust focus on equitable disaster preparedness and response. Is that any better? Is the sound quality any better? All right. I'll get up and close personal. Let me just check my sound here. Is that any better? Wicked. All right. Thank you, Jenny, for that feedback. I was saying stuff. Anyway, there's a focus on equitable disaster preparedness and response. So we think a lot about FEMA. We think a lot about the Stafford Act, legislative reforms that might be necessary. I think I see our role certainly as an academic institution within an elite university based in New England as twofold. One, we try to provide public-facing resources that help folks who might be impacted by really complex environmental and energy regulatory policy to give them a way in to actually access and make their voices heard on those processes that can be really complex, really gnarly, sometimes by design. So that's one piece. And I can throw a couple of resources in the chat. For example, we have a federal environmental justice tracker. And we've just been tracking all the environmental justice policies and actions that have come out of the Biden administration. We are going to revamp this. We started it when we didn't really know it was coming down the pike. Oh, thanks, Zoe. So we are going to redesign it. It will be hopefully done by the end of the year, and you'll be able to filter by all the open public participation opportunities, as an example, by agency, by issue, by statute. So hopefully it'll be much more user-friendly. And of course, we're taking feedback on that. So I'll throw my email in the chat. And if you have something that you would love for this tracker to do, please let me know. And of course, we also produce sort of public-facing resources. So for example, we have an explainer on CEQ's NEPA Phase 2 proposal. Comments just closed. I think there was 83,000 comments on that proposal or something truly bananas. But when we think about, what is our role here, we're really focused on durable environmental regulation, right? Not only do you need to get something across the finish line regulatorily, but you also need to get it past the courts. Certainly in environmental law, everything is getting challenged. And so what are the ways that you can design a regulation, the ways you can design a policy so that it is robust in terms of its equity outcomes, but also durable in terms of judicial review? The other thing we do that I just want to flag is we also partner with organizations. We're not a clinic. We don't provide legal representation, although we do have a clinic. And I'm happy to make that connection if folks want to chat to those folks. But we partner to help organizations engage on very specific issues. So for example, thinking through carbon capture and sequestration, thinking through NEPA, thinking through the Stafford Act. We help provide background information to help folks engage as powerfully as they can, to iterate their position as powerfully as they can. And we also bring folks together. So we do have a convening function where we just try to make sure people are talking to each other. This is especially important, I think, in the disaster space, where you might have legal aid attorneys, for example, who are the experts on how low-income folks interface with our federal disaster system, but are also the least equipped in terms of capacity and funding to actually talk and engage with federal agencies. So I see our role as this translator and interpreter. As someone who's worked as an interpreter, I take this very seriously. Our goal is never to change the underlying message, but to make sure that the key messages are reaching decision makers in a way that is true to the folks with lived experience. So I'll leave it there. I'm probably going to drop a bunch of links in the chat if Zoe hasn't already. And again, just really excited for this conversation.
Thank you so much, Hannah. And thank you so much to all of our presenters. One thing that came up in at least a few of you, few of your initial conversations was this upcoming $2 billion in appropriations. I think starting with Alex, if you wouldn't mind telling us a little bit more about what that looks like and how it will play out.
Yeah, thanks for the question. And I'll also back up a little bit just to set the stage for the moment in time we're at for environmental justice. I am newer to federal government. I did, my 6-month detail in 2022, started this role in February of this year. And it's just been so amazing and yeah, just mind-boggling to see how much change has happened in one federal agency in such a short amount of time. And that's saying a lot for a change in federal agency and the amount of time I've been here. But just a little over a year ago is when the Office of Environmental Justice and External Civil Rights was created. There were 2 offices before, smaller. They then became elevated to a national program office. Just in this past year, we awarded 16 of our TICTACs, which Rob had mentioned earlier, these technical assistance centers across the country in various regions. And then we received the Inflation Reduction Act $3 billion appropriation, which, prior to this, the office had never spent more than a few $1,000,000 awarding small, $250,000 planning grants to community-based organizations. I will say with this legislation per Congress, time is not on our side. It's not on the EPA side. It's not on the community side to execute on this initiative. All of our grants are limited to 3-year implementation timeframe, which creates a whole lot of challenges from the hiring perspective of EPA to get folks on board who can do this work, communities being able to actually develop projects that can withstand that time. But with that being said, I think, Jesse, Rob, Hannah, so many others out there can help communities get to a place where they can receive these funds, implement them, and make meaningful change. So of that $3 billion, we have since awarded 168 communities at $128 million total to really begin to foster projects as well as partnerships, right? To be able to work together to create the level of change that requires collaboration. And then with that, we have $2.2 billion remaining, and that is what we are actually going to announce in the next couple of weeks. So with that, we have $2 billion available for grants and $200 million in technical assistance. And with this announcement, this will really creates the largest shift we've ever seen with environmental justice at the federal level to get from planning stages to implementation, large-scale implementation in disadvantaged communities who have very complex environmental, public health, other challenges. And we really see this as an opportunity to create holistic solutions to these challenges. So we will be offering grants in the award sizes from $10 to $20 million at the community level to tackle a variety of things at once. So climate resilience and adaptation, talking broadly about energy resilience, nature-based solutions, as well as pollution reduction, indoor air pollution, outdoor air pollution, as well as other pollution more broadly, water, ground, all of those things. And all of these will really be centered by community engagement, making sure that applicants have plans to engage the communities throughout the implementation process, in addition to creating plans to avoid the displacement of people who live in those communities as a result of this very large investment that will come to these areas. We will also be able to stand up what we're calling our Community Change Technical Assistance Program, where we have $200 million to support communities, eligible applicants, and applying for these funds. These will require a lot of work. They will require collaborations. They will require that projects are ready. I think what Hannah said speaks very true to me, robust but durable. That's the exact type of approach that we are trying to do with this program. I would say robust, durable, and equitable. We want to make sure that these projects are ready to be implemented within the 3-year time frame. We want to make sure that communities are not set up to fail, but can actually receive the long-term benefits of these investments, and that all of these projects are driven by the community. So that's at a very, high level, broad view of what we have coming down. But we're very excited to announce this funding opportunity, again, the community change grants. And we are also integrating several innovative features, I think from a federal government standpoint, one being that the application period will be open for 1 year. So that different communities aren't feeling that they have to battle each other out at one specific deadline in 3 months, but they can really work, take their time, use technical assistance, and develop projects over 1 year. And we are also not only looking at the quality of the written proposals. We are integrating oral presentation components to make sure that communities can really tell their stories the way that they want and have an opportunity to show different assets that they have, not just those that can be written down on a piece of paper. Several others as well to try and make sure we get these funds out as quickly as possible. But I'll stop there. Yeah, lots of exciting things coming out very quickly here.
Thank you, Alex. Rob, I'm curious, as a veteran of EPA, whether you have any reflections on sort of the size of this investment or how it's being implemented or anything along those lines. I think you're on mute.
Alex alluded to this. I was part of that group of people at EPA who, when we were able to cobble together a few $100,000 for a community to do some planning, actually that was usually tens of thousands of dollars. And every once in a while we were able to provide $100,000 to begin doing implementation. I'm really thinking now of the CARE program, the Community Action for a Renewed Environment, where we were able to help 100 communities with relatively small amounts of funding, like I described. But what we saw was, even with those small amounts of funding, the leadership in those communities is incredible. If you think about it, these are people who had to try to make progress, round up support within the community with virtually no resources. And if you provided them even those small amounts of resources, they were able to do incredible things. And so when you're talking about the level of investment that Alex just described, I think I'm sure we're going to see some very impressive outcomes. And I want to quickly mention one other aspect of this, which is the people who worked on it at EPA, largely people in the regional offices. When we do our planning calls, they would say, this is why I came to the agency, to do this type of work. And I'm so excited to have the chance, even if it's a small program. And I think you're going to see this not only, of course, at the federal level in other agencies where some of that work is where a lot of the work is happening at places like DOE and agriculture, but also at the state level, where people will have an opportunity to implement some of these clean energy and disadvantaged community types of programs. So there are all kinds of ancillary benefits when you're able to do something like this.
Thank you very much. I think next as a topic in terms of just clarifying the language that's being used throughout conversations regarding these pieces of legislation when it comes to terms like environmental justice communities or disadvantaged communities or overburdened communities. I'd love to open this, I think, primarily to Hannah and Alex to sort of discuss what exactly those terms mean in this particular context.
Alex, do you want to go first, or do you have a preference?
Sure, I can jump in and from EPA's perspective, yes, and I'm sure Hannah is more well able to speak to this than I am about how important language and terminology is. And, you know, programs created at the legislative, congressional level, every single piece of that language is dissected by multiple lawyers, and then you know, each agency needs to really develop their legal opinion of how this can be interpreted. For the Inflation Reduction Act, the term that they used within it is disadvantaged communities. And I say that because you know, people in communities that have been marginalized for so long want to characterize their communities in other ways besides disadvantaged, and some do like that term. But I think it's very important that when we talk about many of these federal investments, we be very clear around who's eligible to participate and who is not. And what is authorized by Congress and what is not. So Congress had authorized, and excitingly for our program, said that all of our funds must benefit disadvantaged communities. So all $2.2 billion of it, or $3 billion total. Other federal programs, they need to utilize or go through Justice 40, which allocates 40% of benefits, and benefits can be communicated in different ways. For us and for the program I'm running, we're talking about benefits translating into dollars in communities where people live. That's the way that we're thinking about benefits for us. But shortly after the Inflation Reduction Act, I think after Bill even, the White House had come out with guidance that essentially asked all of the federal agencies to utilize the climate and economic justice screening tool that the White House had developed. This includes several indicators related to air, water, economics, so many different factors that can help pinpoint areas that are particularly overburdened with various indicators and others. They also, though, said that federal agencies, depending on their programs, can submit requests to utilize other tools. So EPA for our programs, and my program specifically, will also be utilizing the EPA's EJ Screen, Environmental Justice Screening Tools, which looks at cumulative impacts a little bit more specifically. So the combination of different indicators, whereas CJUST looks at individual different indicators, and you can kind of select which ones you want to look at to identify a disadvantaged area. I'm not a data or mapping expert by any means, so I'll probably stop there with that. But yeah, I do want to be clear that communities can utilize EJ Screen and CJUST, and some other things that you'll have to wait to see when we roll out the program in order to identify eligibility. Hannah?
I think that's great. I would just add a few other terms that I know are floating around to help folks navigate. And I think what Alex is talking about is the difference between qualitative terms that we're using colloquially and terms of art that have been established in federal guidance, in statute for the first time, and of course, executive order. The one thing that I wanted to flag, Alex mentioned that the term disadvantaged is often something that many communities reject. This was a term that first appeared in New York's Climate Leadership and Community Protection Act, the CLCPA, which established a Justice 40 program for the state of New York. That became the model for Justice 40, an executive order, which used the term disadvantaged communities to say we know 40% of federal benefits, another term of art, to go to disadvantaged communities. So again, term of art for a very specific program with very specific outcomes. The climate and economic justice screening tool spatially maps who is disadvantaged for purposes of Justice 40, right? And then there's other terms that are popping up now that the federal government is building out more and more of its EJ programs. So just as an example, we have energy communities for purposes of the renewable energy tax credits that the IRS is implementing, also under the Inflation Reduction Act. There's also FEMA's programs where we have socially vulnerable as part of their social vulnerability index, which feeds into some of their grant criteria. They also now have community development community disaster resilience zones, or CEDARs. I will put a link to the chat. I'll put a link in the chat to an analysis that we have that tries to break out some of these screening tools that are available in the different terms. I don't think anyone needs to memorize all of these unless you work at a think tank and it's your job. But it's just helpful to ask the question when we say marginalized, overburdened, or disadvantaged, are we talking about it as sort of a demographic qualitative term, or is it a legal term where it has very specific requirements that you need to prove that you've satisfied in order to get access to this funding? The very last thing I'll say on this is that we saw a shift when President Biden issued the update to the Clinton 1994 Executive Order on Environmental Justice. So this is the long anticipated update to Executive Order 12898. This is Executive Order 14096. I apologize in advance for all of these, but I think there we saw a shift from disadvantaged communities and this reaction that communities understandably had to that terminology to communities with environmental justice concerns. And that is a much broader term. It includes non-spatially confined groups. So for example, migrant workers is explicitly named in the executive order. So I just wanted to flag that one last term because you'll see that increasingly in regulatory reviews where agencies under Executive Order 14096 need to flesh out how their proposed rule or proposed action is going to impact communities with environmental justice concerns. And again, that is a term of art that comes from the executive order. So at risk of just overwhelming everybody, I will stop there, but I'll put that resource in the chat on the different communities and screening tools.
Thank you. So Hannah, I'm actually going to tee you up and ask about the Students for Fair Admissions case. But before I do that, I'm here to give you all the CLE code. So if you are here for CLE and you need that code, it is CLEJ7231. And with that, Hannah, I will pass it back to you.
I'm going to throw this link in the chat real fast. I don't want to grab the CLE code, but then we have that link, and the summary of the different screening tools is on page 6 of that document. So yes, we wanted to quickly touch on the Supreme Court's recent decision overturning decades of precedent around affirmative action under the Equal Protection Clause of the 14th Amendment. I wanted to just highlight what this decision is versus what people are saying it is, and distinguish between the true holding and the chilling effect, because both are important, but they're different. So we have the Harvard case, Students for Fair Admission, SFFA, versus Harvard and UNC. Those cases were consolidated before the Supreme Court. The challenge was to the university's use of race as a plus factor among many factors in evaluating applicants seeking admission to these universities. Notably, UNC is public, Harvard is private, but it accepts federal funding. So we saw sort of a broader scope in who this applies to. In short, when you have this racial classification, it triggers strict scrutiny, which as a reminder means that you need to show as the government that your use of race satisfies, is narrowly tailored to a compelling government interest. So you have to prove both. And the court said, no. Your use of race here fails to pass strict scrutiny and therefore is a violation of the Equal Protection Clause under the 14th Amendment. I think it's important to flag their decision did not reach Title VI of the Civil Rights Act. This was something a lot of us were looking for and we didn't see. So there is no direct impact on Title VI. That said, I want to talk about the chilling effect. So we have seen a lot of challenges now to DEI programs, including DEI programs in private institutions across the country. And even though this decision was limited to university admissions programs and the explicit use of race in evaluating individuals for admissions, I think we see a lot of concern about what is a general trend in the Supreme Court to overturn decisions that have enjoyed respect for decades, and certainly seeing a lot of forum shopping and concerning decisions in the lower courts around the use of race, around the use of terms like disparate impact. I'm happy to talk more about the Louisiana v. EPA suit if that's something folks want to get into. I think for purposes of these programs, and certainly programs like Justice 40 that try to distribute benefits in a way that will address historic disinvestment, whether it's on the basis of race or other sort of demographic or other identifiers, I think what is relevant is that we're seeing federal agencies understandably be really hesitant to explicitly use race. And this was even before the Supreme Court handed down their decision. So for example, in the design of the climate and economic justice screening tool, CEQ received a lot of critiques for not using explicitly race and ethnicity as criteria to define disadvantaged communities. What they did instead was use proxies, like a legacy of redlining. We know race is strongly correlated to environmental burdens, to income. And so they tried to use other, well, I can't speak for CEQ's intent, but the result was that they used a series of factors that closely approximated what you would have gotten had you used race and ethnicity explicitly. And there was a great GRIST article that evaluated that difference. And so I think this is something we're seeing across the board, is how do we get at race? And most importantly, how do we remedy the very real and harmful legacies of disinvestment based on race and overt discrimination, but still pass muster based on this new colorblind version of the Equal Protection Clause? I'll stop there. That was a lot of information all at once. Everyone else should feel free to jump in.
Thank you very much, Hannah. I think we'll sort of move from the more theoretical to a little bit more of the practical side of accessing these funds at this point, with regards to sort of practical and technical advice for communities and their representatives to sort of access these funds that are coming down. In line with this is a question we have in the chat for Rob. What are some of the challenges you anticipate groups will encounter in trying to access this money? So if you wouldn't mind speaking from sort of EPN's wealth of knowledge with regards to advice for applying for these money. You're on mute still.
It's apparent from Alex's presentation that the agency is going to be doing some things that have never been attempted before to make these funds as accessible as possible. And of course, the package is not yet out, so I don't want to presuppose exactly what the requirements will be. So I'm just going to talk very generally here, which is to say that there are going to be, of course, various kinds of legal constraints in how money can be issued. And I'm sure there's going to be some times when EPA is really going to need to struggle with how do you make this as streamlined and navigable a process as possible, but still make sure that it's going to withstand the legal and congressional scrutiny that is pretty much inevitable to happen with any kind of grant program, not just this. So that's where these guides that I'm talking about, I think, become very important. As I mentioned, we've done guides in the past, and you can look on our website and see how they work in terms of step-by-step suggestions on how to apply for them, and links with definitions that are going to be important for communities to be aware of. And also, hopefully, we'll also be able to do a template for what an application might look like, along with an example of an application that we might be able to make up. We did that for some of the other programs because it is going to be a challenge for communities to access the funds. But I'm hopeful between the kind of guides that are going to be developed and the way in which the agency is structuring it, those hurdles are not going to be insurmountable. But let me say one more thing about communities accessing it, and that's that we have on the webinar here, we have NGOs who are used to applying for funds from government agencies and from foundations. We have foundations who are used to doing these kinds of processes, and we have businesses. And I think that it's really important to see if there are opportunities to link up with communities. And there are foundations that have done work, extraordinary work with communities, and maybe they can help them with the application process here. Similarly, the environmental community, especially over the last few years, has really stepped up and tried to do what it can to focus on environmental justice and disadvantaged communities. And they've developed some relationships and are continuing to develop relationships. And I think it's really important to try to take advantage of those relationships and the new ones being built and work with communities to help them with these applications. And finally, I'll go a step further and say, I know that the relationships between the business community and disadvantaged communities are not always the best, but there's certainly good examples out there of where businesses have developed those kinds of relationships. And for businesses who want to develop those kinds of working relationships, and for the communities that are open to them, what better way to begin to work together than to try to help to obtain resources for these communities to be able to use for clean development and for cleaning up previous pollution problems. So there are a whole series of local partnerships that need to take place here, in addition to EPN and some of the other national organizations trying to provide guides at the national levels. But I really should kick it over to Alex to give her a chance to either correct some of the things that I'm assuming or make some additional suggestions.
No, I think that's great. And I'd actually love to hear from Jesse. I think Jesse's experience and background's so spectacular. I'm sure you have a lot of insight to this as well. You know, one of the other major things is, of course, capacity. And I think that goes back to Rob's point, which is, you know, it's really important.
Did Alex freeze?
Right now around electric utility resilience, one of which is Together New Orleans Community Lighthouse Project, which is converting churches and other community centers into resilience hubs by equipping them with solar panels and battery backup systems. There's another similar project called Get Lit, Stay Lit, which is equipping restaurants in low-income neighborhoods with the same sorts of solar and battery backup systems. So we see enormous opportunity here for real community-led initiatives. But I would say, just, you know, from the Native perspective and just from the environmental justice community perspective generally, that you know, when consulting with tribes and with EJ communities, too often it becomes, you know, just a box to check. And so, you know, really following the lead of tribal nations and EJ communities and really listening to their concerns and what they have identified as their needs is important to successfully implementing this legislation.
Thank you. Alex, is there anything else you want to add to finish up where you got cut off?
No, that was amazing. No, I'm just very glad we have folks like Jesse, Rob, Hannah, so many others across the country. We did a number of listening sessions to really hear what those challenges are. I think from where I stand, it's difficult when there's things you can tackle at the programmatic level, and then there's things that are more at the structural institutional level in terms of grant requirements and things like that. So we're trying the best that we can, but anytime there's an opportunity to hear about how we can make things better, me and my team especially are all open ears. So yeah, really appreciate those comments, Jesse and Rob.
Thank you. And we have one more sort of practical question in the Q&A box. Again, to everyone listening in, please go ahead and put any questions you have in the Q&A box so that we can get to them. But the question is, if a tribe or organization spans 2 U.S. states, how do you recommend applying for funding? So if someone is willing to touch on the role that state lines play in this process.
Oh gosh, I'm not an expert on state line boundaries. I don't know, Jesse, if you've had experience in that in particular. I think as far as pursuing grant funds goes, there's a lot of funding available. And so, of course, there's a lot of work that can go into one grant application. But one of the things that we're instilling as part of our program is allowing for multiple submissions. So a tribe, for example, can receive 2 grants to support 2 different communities. But at the same time, in terms of my program, we do not try to define what a community looks like to different communities across the country. We're trying to instill a process where they tell us what their community looks like and how they want to apply for funds accordingly. So that's not something that we'll be looking at specifically. I think from a more challenging perspective is the actual implementation of capital infrastructure. I can definitely foresee it being more difficult and complicated to get, one set of requirements. But I know that tribal governments are sovereign, so I can definitely foresee it being a little bit more complicated. But also encourage you to think about different ways you could either apply for different applications or hopefully our program will allow the flexibility to be able to fund multiple communities that a tribal government and community that goes across 2 different states. But yeah, I don't know, Jesse or Hannah, if you have any thoughts on that.
Might throw in really quick, I'll put a link in the chat. HUD Exchange just put out a funding navigator last month that allows you to sort through all the federal funds under the IRA, the IIJA, other, but you can click a drop down that says audience and you can pick your, are you a nonprofit? Are you a federally recognized tribe? Something else, and that will show you the relevant funding. So there are a lot of grant programs that don't go to states. They go to nonprofits. They go to coalitions of states and nonprofits or states and tribes. So I would recommend sorting based on who you are and going from there so you can pick the ones that just make the most sense. So I'll throw that link in the chat in case it's a helpful resource.
That's a great point, Hannah. And I do want to mention for at least the funds that we'll have coming out for Office of Environmental Justice, these will be able to go directly to tribal governments, CBOs, as long as there's a partnership between a CBO and a tribal government. That's totally eligible, which, yeah, that was one of my realizations when I came to the federal level is, a lot of these grants go directly to states. That's not the case for us.
All right, thank you all so much for your thoughts on that topic. Taking a step back, thinking a little bit into the future, knowing that attorneys' favorite things are to speculate, envisioning how these pieces of legislation play out in the long term. And Jesse, from the Gulf South perspective, does it seem as though the benefits will sort of be experienced equally across the country. How impactful do you see this legislation being on broader goals, like a just transition, for example? Just thoughts on how those things will play out.
Yeah, thank you. You know, as the cliche goes, the devil is in the details. And I think, you know, the language of all this legislation is permissive or vague enough, however you want to characterize it, that it really comes down to state and local level implementation. You know, that can go a variety of ways, whether these funds are being funneled to things that we know are proven solutions like energy efficiency and renewable resources, or, you know, to things that, you know, at least we at the Alliance and our allies would characterize as sort of false solutions to our climate crisis, like carbon capture, which is heavily favored by a lot of this legislation, in which, you know, our state Department of Natural Resources down here has applied with EPA for permitting primacy over deep injection wells for carbon waste. This is an agency that already has regulatory authority over oil and gas wells in the state, which they have lost several thousand of, and had to receive an infusion of federal funding this year to help cap those abandoned wells, because they have been, you know, far outpaced in terms of their capacity to deal with that regulatory burden. And now they're asking for this additional regulatory burden for carbon capture projects, which are being touted as, you know, a solution to the climate crisis, but which the White House Environmental Justice Advisory Council has rejected as a false solution. And so, you know, again, it comes down to the details of how this legislation is implemented. And I would say that it's certainly, you know, it's certainly true that there are areas that need this funding more than others. You know, just looking at the narrow lane that I'm in of energy regulation, electric utility regulation in New Orleans, for instance, you know, the need for resilience. I have a coworker, one of my colleagues at the Alliance has had 3 power outages just this week. And we've had relatively fair weather this week. It's been a little windy, that's it. But I would say that, you know, in New Orleans, we have one of the highest energy burdens in the country. Let me see, let me pull up my little notes here. Yeah, so low-income households in New Orleans face one of the highest energy burdens in the country. Half of our low-income households have an energy burden of greater than 9.8%. So what that means is that of these low-income households, almost 10% of their household income is going to their electric utility bill. A quarter of those low-income households have an energy burden of 18.9%. Some of them ranging as high as 28%. So you can see that the need for lowering utility costs is great. The reasons for that discrepancy are manifold here in New Orleans. One of the reasons is that we experience a heat island effect. Climate Central released a report last year or the year before detailing this heat island effect, which showed that New Orleans experiences temperatures of about 9 degrees higher than surrounding areas, and lower income neighborhoods within New Orleans experience temperature differences of upwards of 18 degrees from surrounding areas. So, you know, they say it's expensive to be poor, and it shows in these statistics because these problems just compound on each other. And then, you know, on top of that, we're a very renter-heavy city. We're a majority renter city, in fact. So that means that folks are very limited in what they can do to their properties in terms of energy efficiency, putting on rooftop solar to help with these sorts of issues. I know I've gone on a lot, but I really want to emphasize that, you know, the way that this money is allocated and distributed is really going to be the measure of how successful this legislation is. It really comes down to those details.
Well, let me add on to that, because of course the way the money is distributed is going to be important, but as we've talked about, there are, and you mentioned, there are requirements in the legislation for how some of the money is going to go out, and it's not going to be in ways that everybody is going to like. That probably goes in both directions. But the point is that there are enough different types of programs that as bumpy as the rollout will inevitably be, there are going to be some very good and some spectacular projects that come into place. And I think the important thing is going to be that over time, we develop mechanisms to track these projects and to show the ones that are not so good, what were the results of those, how much money was spent, how much benefit was received. And then the ones that were very effective, again, how much did they cost, what were the benefits that were received by them, and be able to build the case for the good stuff. And so I think it's important to think of this whole initiative in part as a demonstration of the next generation of technologies. I think of it as, I was very involved in the rollout of the 1990 Clean Air Act. And in the legislation of the 70s and the 90 Clean Air Act, we were really trying to make the existing technologies work better. But here, what we're trying to do in large part, not completely, but in large part, is to develop a whole new set of technologies, a whole new generation of technologies that will make sense from a sustainability, climate change kind of perspective, and also be beneficial in terms of equity and development around the country. So a lot will depend on how good we all are at tracking the results and really doing a good job of quantifying the results so that in the longer run, we get more of the good stuff and less of the not so good stuff.
Thank you. Hannah or Alex, do either of you have anything to add? Awesome. Well, as a reminder to you all, please remember to put all of your questions in the Q&A chat box. I think we have about 15 minutes left on this presentation, so hopefully we can get to as many of them as possible. Hold on a moment. It's a long question. It takes me a second to read it. So one of the questions in the Q&A is that related to students for fair admissions. Do you recommend people continue to use race-based factors, acknowledging the limitations of the case holding, or do you recommend taking a more proactive and conservative approach, or any other thoughts on approaches moving forward?
I can get us started. I'm not going to give a satisfying answer. The great way to lead off, but it's a great question. I will give the classic attorney answer, which is it depends. I think it depends on your goals. It depends where you are, and it depends who you are. So for example, if you're a federal agency and your focus is durability, you know, we've already seen, for example, there was a program created under the bipartisan infrastructure law that was designed to target Black farmers and give them additional loans. And it was an explicit race-based criteria. And that was challenged in a federal district court in Florida. It was struck down as a violation of the Equal Protection Clause. And I think a lot of attorneys were surprised by that decision because the USDA has a very well-documented history of overt racial discrimination against Black farmers. So the thinking goes, if it failed there, where can we use race-based criteria and survive judicial review? So I think, again, speaking for myself, I think it is smart for federal agencies, particularly under the Biden administration, where we are running up against the clock potentially, to use other criteria that will survive judicial review so that we can try and get as much of this funding out the door as possible. That is my personal hot take. I'm not speaking for EELP or any other organization. I'm speaking for myself. That said, I know there are many organizations who are thinking strategically about what the doctrine should be and trying to get good law. And so it's just a different strategy depending on what your aims and your strategy are, and certainly who you are. So I'll leave it there. And I know there was a really wonderful explainer that came out of Just Solutions and the Green Lining Institute and others. So I'll try to find that resource and put it in the chat as well. And it includes some legal guidance on, how do you pick the strategy that's right for you.
Thank you. And just a note on the number of resources that are being shared in the chat. When we put up the recorded version, it does not have the chat on it, but we will have it in our records. So we'll go through and sort of comb for all of the links and post that as a separate document on the same event page, just so that all of these different resources that are being discussed are preserved and accessible from there. Another great question from Jeff: tracking benefits of projects implies having a baseline at the beginning to measure progress against. So is that part of the application for a project, or how is that included, or how can communities work to use that as a reference for themselves?
Yeah, I can start off, and then yeah, anyone else feel free to jump in. Yeah, this is a very interesting question because I know benefits again is a word, as Hannah would say, I think a term of art at the federal level, and there's various guidances coming out in terms of how different programs can quantify benefits. My hope is, with the way that we've developed this program, these funding opportunities, that I can speak to, is that we will allow flexibility for benefits that might not necessarily require that baseline hard data that you would need to create that baseline and then to quantify later on. It is my understanding that because especially the Inflation Reduction Act funds and also Bill, it's important that we track those benefits, but different programs have different discretions in terms of what that looks like. And so my hope is that us and many others will take a more flexible approach so that communities aren't seeing that as a burden. And yes, I do imagine that there will be some sort of application requirement around demonstrating what those benefits might look like. But again, my hope is for flexibility. So we'll see.
As a veteran of benefits analyses, because we did many of them in implementing the Clean Air Act, I completely understand some of the concerns regarding benefit cost analysis. It's pretty easy to quantify the cost. It's often much more difficult to quantify the benefits, and people tend to focus on what's been quantified rather than what's shown in qualitative terms. However, it is a very effective tool for showing why these programs have been important. When we were able to demonstrate that the benefits of the Clean Air Act were at least an order of magnitude larger than the cost, that was a surprise to many of our critics, and it was a very effective response. And so, and in this case, the costs are not as great because they are coming from these programs that have been put in place. So it's not as though there are businesses and communities that are being required to put up these costs. These costs, I would argue, are part of the baseline. They've been enacted and put in place by Congress, and so those are typically considered part of the baseline for evaluating costs and benefits. The trick will be asking communities or helping communities, if they don't have the tools to do it, to figure out what the starting point is in terms of where they are with respect to health and to costs of energy and the other kinds of things that you'd want to put into a baseline, and then see what the impacts are of these new programs. But I would say those are investments worth making. It's another example of where templates can be really valuable if those of us at the agencies and in groups like ours and other groups who are on this call can develop some of those templates and help communities use them. I think it'll pay big dividends down the road because these programs are certainly going to have positive benefits for these communities.
Thank you both. An interesting question, recognizing that none of you are directly connected with law school clinics at right now, but certainly are adjacent. And Jesse, I know you used to be a student in the environmental law clinic at Tulane. One of the questions is whether it's wise for law school clinics to engage in this work in terms of offering communities assistance with funding opportunities from the perspective of students. Do you think this wave of work will be a quick wave now and then dry up, or whether it'll be a lasting need as well?
I would say it's a very interesting idea. I think it's outside of the scope of what most law clinics typically do at law schools, but I don't see any reason why it couldn't be something that they do. I think it would be valuable assistance, certainly.
Awesome. And along similar lines, someone asked about volunteer opportunities, and if any of you all have recommendations for how to get involved in more of this, pro bono work of this nature or pro bono work in general.
Can I broaden it?
Go ahead.
So as an attorney who doesn't litigate, I think it's important to think about volunteer bigger than pro bono. I think because so much of the EJ work that we're seeing, at least coming out of the federal government, what we're talking about in this webinar is funding related. I do think there's a really crucial translation function that attorneys are uniquely equipped to fill, because so much of this language is gnarly. And we're used to speaking in acronyms. Like, we know what a NOFO is, and we know what an RFI is, and we know how to navigate regulations.gov. And those are really crucial skills. And so I think one place where, just speaking for EELP, where we've seen a huge demand that we've tried to fill is to meet organizations where they're at, meet coalitions where they're at, listen for what they're interested in, and try to bridge the gap to say, here are the opportunities that I see out in the world that feel relevant to what you're asking for. And if you wanted to engage, I can walk you through it. Now, it's not a typical role for an attorney. We're not telling people what or how to engage, or maybe we're telling them how to engage, but we're not saying what they should say. But I think, as an example, if I was talking to a group recently about commenting on the NEPA Phase 2 proposal, and they're saying, we're really interested in the EJ and climate provisions, but we're not really sure what environmental assessment is, what is an EIS, like, how do we translate our concerns into this really complex proposal that's coming after a long line of regulatory changes? Environmental attorneys are uniquely equipped to play that translation role. So if you can find a way to be that translator, I think there is a huge need for it right now, not just in funding and helping folks navigate the funding process, but also engaging in all of the regulations that are coming down the pike right now, certainly before the CRA community, excuse me, I keep thinking about the Community Reinvestment Act lately, but I'm having a brain fart. We just say the CRA way too often, but we're going to see a lot of regulations, certainly environmental and energy space, before May. And if we can help groups understand which rules matter the most, which rules they will be impacted by, and help them communicate those concerns to agencies, I think that's really, really, really important.
Thank you so much, Hannah. So with about 5 minutes left of our time together, I would love to open it up to you all for any closing remarks or reflections on the conversation that we've been having.
Well, I'll start. I'll make the comment that, first of all, of course, this has been a conversation well worth having. How do we do what we can to make this whole set of programs work well and happen sooner rather than later, given the constraints that we've all talked about. So that's important. And then I'll build on something that Hannah just pointed out, which is meeting groups where they're at. And I mentioned it briefly when I opened. It's really important to allow the communities to set their priorities and then help them go in those directions. Sometimes they're not going to be aware of what their options are, and we can help them understand what some of the possibilities are. Other times, they know what they want for their community, and it's a matter of looking at these dozens of programs out there to see which ones can be helpful to them. But it's going to go a lot better, and it's also a lot more appropriate for communities to take the lead in priority setting.
I think, for me, just hearing about all of these funds, even before I came over to the federal government, can just be very overwhelming. I think that's, I've heard that a lot over time. I didn't even know Hannah's team was doing all these, creating all these tools to track all these programs. Like, that's amazing. And I know many others are doing that too. And I think you can go like one of two ways. Like, I'm gonna, really pursue this, pick one, look at the broad scope, or just kind of take a step back. Maybe this isn't my field. There's others out there, which is true as well. But my perspective is that everyone has a role to play in this, and we really can't let this moment slip away from us. We don't know what the next term is going to look like. My position's limited 2 years, Inflation Reduction Act. We don't know, we can't totally, we never know what's going to come next. And so I just really encourage everyone to take advantage of this opportunity and see the incredible role that you can play in this effort. The translating, interpreting what these things mean. I need that help all the time from my lawyers and understanding what my own constraints are with designing something which is very ambitious and different. Jesse, the different technicalities that you've probably built so many skills around in your organization around energy resilience, utilities, different regulations, requirements, and Rob, of course, all of the amazing you all work are doing to educate folks around how to navigate these. So yeah, and what sparked that for me is, one of the questions here, a couple of the questions, one around, do you think this wave will be a quick wave and then dry up, or will it be a lasting need? Unfortunately, there's so many issues across the country. I think we'll always need all hands on deck for a variety of different funding opportunities. And then also another question, how will we ensure that these resources are meeting those who are most vulnerable, most marginalized? Unfortunately, that can't just require the federal government. There's no way I can reach anyone. We don't always know best how to engage. So yeah, I'll stop there. Thanks.
I can jump in very briefly, and then Jesse, you can have the last word if that works for you. And second to Jenny's note in the chat about EDF and Columbia's IRA tracker, that's also a great resource on IRA specific funding. I was going to offer a very specific strategic recommendation, which is there is a program under the IRA called the Climate Pollution Reduction Grants that EPA is running. It is for states. But it is a great access point to get a sense of what your state is planning to do on climate. And I say that for two reasons. One, EPA is requiring that the states include meaningful community engagement plans in those climate plans, which means they need to be reaching out to community to figure out what is it that communities want from us to put in our plans. The reason I also mentioned the CPRGs, again, climate pollution reduction grants, is that they require the states to look at the suite of federal funding that's available under the IRA and talk about how they're going to access all of it to achieve very specific climate goals in specific sectors. So if you live in Oregon and you really care about equitable transportation infrastructure, you should try and reach out to your state DEP and say, what are your climate action priorities that you plan to put in this plan? What is your strategy for meaningful community engagement? And can I sit down and have a meeting with you about that? Because they are doing that right now. So that's my pitch. And if you are part of a state government, EELP is part of something called the Conveners Network that is actually bringing states together to help them do some peer-to-peer exchange and learning to say, here's some cool stuff that states are doing over here. Do you want to try and put that in your plan? What does meaningful community engagement look like? And trying to just help states be as robust as possible in that planning process. So I'll put a quick link to the Conveners Network in the chat, but really encourage folks to check out the CPRG program.
So I guess I would just end sort of singing the same refrain I have been singing the whole time, which is just, leaving on a word of caution, which is to say that, the IRA in particular was touted as, the largest investment in greenhouse gas reduction and climate mitigation and adaptation in history. And that could possibly be true, but it also could turn out to be the opposite. Depending on how this money is spent, we could actually see emissions increase if we're diverting funds to projects, that, as I said before, are false solutions. Not all of these sorts of climate responses are created equally. And so really listening to frontline and fence line communities and following their leads is really going to be the measure of success of this legislation. And just a final point on, we talked about metrics a little bit. I think that's extremely important, particularly when we're talking about private entities receiving these dollars. Here in New Orleans, Entergy New Orleans just received like $50 million from DOE in GRIP, or grid resilience funding, under the bipartisan infrastructure law. So, that's matching funds, which means ratepayers are going to have to pony up the other $50 million for this grid hardening and resilience project. So there need to be guarantees in place that the results and benefits that are being promised actually materialize from this investment. And so having those kind of metrics and evaluations in place is also going to be key.
Thank you so much, Jesse, Alex, Rob, and Hannah. It was absolutely wonderful to have you all here with us today. Right before we wrap up, I'm just going to pass it to Madison for some quick ending points.
Thank you so much to all of our wonderful speakers. We're so grateful for you taking the time to be here with us and all of your time and energy preparing this great content. Thank you as well to our audience for tuning in today. As a reminder, for those seeking continuing legal education credit, please be sure to fill out our certificate of attendance request form. We've posted the link in the chat. Additionally, we have 2 different course evaluations, one for attorneys who are in Pennsylvania and one for attorneys in other jurisdictions. We'll be emailing these links out to you with your certificate of attendance, so you don't need to grab it now. But if you want to complete it now while the program is fresh in your minds, we're also posting those links in the chat. Should you have any questions about CLE credit, please email us at cle@eli.org. Thank you all so much once again, and we hope to see you at future ELI events. Have a great day.